So the Wisconsin police threatened to arrest a 16-year-old girl and or her parents for disorderly conduct for a post the girl put on her Instagram feed about having survived the My Coronavirus. And I've got to tell you, this reminds me of a very wise saying by Thomas Jefferson: when the government fears the people, you have liberty, and when the people fear the government, you have tyranny. Viva Frei, Montreal litigator turned YouTuber, and I accidentally used my outro maxim at the intro of this vlog, but stick around to the end of this vlog nonetheless for another insightful maxim. This story has been making its way around the news, and I started getting messages in my DM to cover this story, and I've got to say, when I first read the DMs detailing what the story was, I did think it might be something of an exaggerated fake news type exaggeration. What? The way the story was being described to me in DMs, in comments on some of my videos, I thought maybe there had to be some exaggeration, some rumors, etc., but I have now read the lawsuit, and if these allegations can be substantiated, what a world we are living in. The story is, in fact, about a 16-year-old girl who came back from a class spring break where they went to Disneyland or Disney World, I forget which, but she came back and she started experiencing symptoms that people attribute with the My Coronavirus. We'll get into the details of the story as we go through the lawsuit, but the bottom line is she posted on Instagram something to the effect that she had survived the My Coronavirus and that she's wishing everyone good health. Apparently, her school didn't much appreciate the post, reported it to the police, and the police apparently showed up at her door, told her to delete the post, otherwise they were going to arrest her and or her parents for disorderly conduct. And the girl, through her parents, filed a First Amendment lawsuit for declaratory judgment and nominal damages, and we're going to go through that lawsuit right now. United States District Court, Eastern District of Wisconsin. Amia Cahoon, a minor, by and through her parents and legal guardians, Richard Cahoon and Angela Cahoon. Plaintiff versus Joseph Conrath in his personal and official capacity as Sheriff of Marquette County, Wisconsin, and Cameron Klump in his personal capacity as Patrol Sergeant for Marquette County, Wisconsin. Defendants. Complaint. Plaintiff Amia Cahoon, a minor, by and through her parents and legal guardians, Richard and Angela Cahoon, by and through the undersigned counsel, brings this complaint against defendants Joseph Conrath and Cameron Klump. In support of this complaint, plaintiff alleges as follows. The First Amendment's protection of free speech, especially online speech, is as vital as ever during the ongoing My Coronavirus. And in case you're new to the channel and you have no idea why I'm talking like this and what on earth I'm saying, I have dubbed this illness the My Coronavirus so that YouTube doesn't automatically flag and demonetize my videos on the subject. It seems that there are in fact certain terms that you are allowed to use without having your videos automatically demonetized, and others that you are not allowed to use, except nobody really knows what those words are, so I have created the term My Coronavirus to describe this schmillness. And the schmandrick, well, I just made that one up because I like the way that sounds. The unprecedented stay-at-home orders throughout the nation have made social media one of the few outlets people have to communicate with friends and family. This case is about preserving the right to share our experiences with each other during this difficult time. A high school student who had a scare with the My Coronavirus posted about her experience on Instagram, and a few days later, a deputy sheriff showed up at her home and demanded that she remove her post or be cited for disorderly conduct, arrested, and jailed. The offending post? A picture of the student while she was hospitalized for what doctors told her was likely My Coronavirus, with the caption, "I am still on breathing treatment, but have beaten the My Coronavirus, stay home and be safe." The sheriff's actions blatantly violated the First Amendment, and plaintiff is entitled to recognition of that fact. The bottom line, this is a First Amendment lawsuit seeking a declaratory judgment that the First Amendment rights of the plaintiff have been violated and seeking nominal damages. And in my very humble Canadian opinion, I don't think on the substance of it that there's going to be much argument that First Amendment rights were violated. We'll get there, but with that said, let's just skip through the facts so that we know exactly what's going on here. We have a description of the parties, which I'm going to skip over just because it contains identifying information of the plaintiff, who is a minor. We have the typical jurisdiction and venue clauses. This is all boring. Let's just get to the facts. Amia Cahoon is a sophomore at Westfield Area High School in Westfield, Wisconsin. Between March 7 and March 15, Amia went on a spring break trip to Disney World and Universal Studios in Florida with her high school's band class. While Amia and her classmates were in Florida, the country began shutting down due to the My Coronavirus schmandrick. On March 9, Florida Governor Ron DeSantis declared a public health emergency for the state of Florida. On March 12, Universal Orlando Resort in Florida announced that its theme parks would close on March 15 due to the illness. Paragraph 18. On March 22, 1 week after returning from Florida, Amia began having difficulty breathing, so her mother took her to the emergency room at Divine Savior Hospital in Portage, Wisconsin. The doctors there evaluated Amia and concluded that her symptoms matched those of the illness, but they could not test her due to the criteria at the time. They sent Amia home with an inhaler and instructions to strictly self-quarantine and to return if her condition deteriorated. They also told Mr. and Mrs. Cahoon to self-quarantine for 14 days. The discharge order, a true and accurate copy of which is attached hereto as Exhibit 1, diagnosed Amia with an acute upper respiratory infection unspecified. The doctors also gave the Cahoons a work release form, a true and accurate copy of which is attached hereto as Exhibit 2, specifying that, quote, Amia has symptoms consistent with My Corona. Based on the information supplied by the doctors at Divine Savior Hospital, Amia and her parents believed, and still believe, that her symptoms were caused by the illness. It's something I frequently say in my vlogs, but it's always worth repeating. These are just allegations. These are not proven facts. These allegations would have to be proven in order for the plaintiff to succeed on her claim. So assuming these allegations can be substantiated, the plaintiff goes to Florida on spring break, comes back a week later, starts falling ill with symptoms closely resembling those of the My Sharona Cyrus. After they left the hospital on March 22nd, Mrs. Cahoon called the band teacher in charge of the spring break trip to notify her about Amia's condition so that the school could warn other families with students on the trip that Amia may have contracted the illness. Mrs. Cahoon was unable to reach the teacher, so she left a voicemail but never heard back. After she got home from Divine Savior, Amia posted a picture of herself from the spring break trip with the caption, "Hey guys, sorry I've been on a long break. I won't be back for a while longer due to me now having the My Sharona Cyrus. I don't want the attention, it's just the truth. I am now in self-quarantine and have an inhaler since they said to go home. Best of wishes, love you guys." On March 25th, Amia's symptoms worsened, including significant difficulty breathing, so Mrs. Cahoon took her back to the emergency room at Divine Savior Hospital. Paragraph 30, Amia was finally tested for the illness in the evening of March 25th and received the results the following morning. The test came back negative, but the doctors told the Cahoons that Amia still likely had the illness and had missed the window for testing positive. After she returned home, Amia posted again to Instagram, this time a picture of herself at the hospital with an oxygen mask on her face. The caption on this post read, "I am finally home after being hospitalized for a day and a half. I am still on breathing treatment but have beaten the My Sharona Cyrus. Stay home and be safe." And this is where it gets interesting. During the evening on March 27, Defendant Patrol Sergeant Cameron Clump from the Marquette County Sheriff's Office came to the Cahoon's home. After Mr. Cahoon came outside, Sergeant Clump explained that the school superintendent had complained to Defendant Sheriff Joseph Conrath about one of Amia's Instagram posts. Sergeant Clump stated that he had direct orders from Sheriff Conrath to demand that Amia delete this post, and if she did not, to cite Amia and or her parents for disorderly conduct and to start taking people to jail. Later that evening, the Cahoons discovered that earlier in the day, Westfield District Administrator Bob Meisher had sent an update to families in the school district that included a statement about Amia's posts. Administrator Meisher's update stated that, quote, "It was brought to my attention today that there was a rumor floating out there that one of our students contracted the My Sharona Cyrus while on the band trip to Florida 2 weeks ago. Let me assure you that there is no truth to this. This was a foolish means to get attention, and the source of the rumor has been addressed. This rumor had caught the attention of our public health department, and she was involved in putting a stop to this nonsense. In times like this, the last thing we need out there is misinformation. I asked her to prepare a short statement for the purposes of this update. I've pasted it below." Another thing I frequently say in my vlogs is that when it comes to law, there is the legal side of things and there is the human side of things. And when it comes to this story, it sounds like there's a lot more going on behind the scenes than just the legal side. Not knowing anything more than what I've read in the allegations of this lawsuit, I would be surprised if there wasn't already a history between the Cahoons and the school. Not knowing anything more, I don't know anything. I just suspect there might be something of a history between the parties. I might also suspect that the school doesn't necessarily want the potential bad publicity that might come with having taken a spring break school trip to Florida. I don't know exactly what was going on at the time they did this, but there might be some questions to ask about the timing and the opportunity of that trip. I don't know what relationship exists between the school superintendent, the sergeant, or the sheriff, but I suspect that there might be something of a pre-existing relationship that would explain why the sheriff and the sergeant reacted as quickly as they did. But this is all hypothesizing and conjecture, just questions I might ask given the circumstances. It seems that there is something more to this story than a mere Instagram post. Regardless, the police literally show up at this girl's house and demand that she delete an Instagram post, failing which they might arrest her and or her parents for disorderly conduct. When I read this, the first question I asked myself is, how on earth could this possibly constitute disorderly conduct? So I went and pulled up the provision for disorderly conduct in Wisconsin, which reads as follows. Disorderly conduct. Whoever in a public or private place engages in violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct under circumstances in which the conduct tends to cause or provoke a disturbance is guilty of a Class B misdemeanor. Well, if that definition doesn't just possibly include any behavior on earth depending on the circumstances, I don't know what does. I didn't draft this law, I didn't pass this law, I just read this law. How on earth could this 16-year-old girl's Instagram post possibly qualify as disorderly conduct? Well, I guess it amounts to the discretion of the arresting officer. And does the threat of arrest for failing to delete an Instagram post violate the First Amendment? Well, I am sort of swayed by the argument I read in the pleadings. Paragraph 61. The First Amendment prohibits government officials from, quote, subjecting an individual to retaliatory actions for engaging in protected speech. Any form of penalty for protected speech is forbidden. The principle applies equally to law enforcement. Officers may not cite cite, arrest, jail, or threaten individuals with any of the above for engaging in protected speech. Plaintiffs alleging that they have been penalized for protected speech must show three things. 1. That they engaged in activity protected by the First Amendment. 2. They suffered a deprivation that would likely deter First Amendment activity. And 3. The First Amendment activity was at least a motivating factor in the official's decision. Now, just to open up a parenthesis on First Amendment freedom of speech rights, they are not limitless. There is protected speech and there is not protected speech. And quickly pulling from Wikipedia, exceptions to speech in the United States refers to categories of speech that are not protected by the First Amendment. According to the Supreme Court of the United States, the U.S. Constitution protects free speech while allowing for limitations on certain categories of speech. Categories of speech that are given lesser or no protection by the First Amendment and thereof may be restricted include obscenity, fraud, CP, speech integral to illegal conduct, speech that incites imminent lawless action, speech that violates intellectual property law, true threats, and commercial speech such as advertising. So free speech, even in the United States of America, is not limitless. The only question is whether or not this particular free speech, the Instagram post, is protected speech. Anyone want to place a wager as to whether or not posting on Instagram that you had survived an illness, even if it is not true, is protected speech? Paragraph 66. As the Supreme Court has recognized, social media is, for many, the, quote, principal source for speaking and listening in the modern public square. And while certain categories of speech are excluded from First Amendment protection, obscenity, defamation, true threats, inciting violence, etc., none of those narrow exceptions apply to Amia's posts. I would be extremely surprised if there's actually going to be any meaningful argument as to whether or not Amia's post on Instagram constitutes protected speech. The next question in law is whether or not being threatened with a citation or arrest for exercising your free speech is a limitation on free speech. If we agree with the argument in the lawsuit, no, there is going to be no question on that either. There is also no question that defendants' threats of citation, arrest, and jail are a sufficient, quote, deprivation to violate the First Amendment. The Supreme Court has long recognized that, quote, a realistic threat of arrest is enough to chill First Amendment rights. And then the plaintiff addresses the issue of probable cause as to whether or not the police even had sufficient probable cause to come and cite or arrest her in the first place. Finally, defendants did not have probable cause, or even remotely close to having probable cause, to cite or arrest Amia or her parents for disorderly conduct. Amia's Instagram posts about her experience in the hospital were in no way violent, abusive, indecent, profane, boisterous, or unreasonably loud, nor could they reasonably be characterized as, quote, disorderly conduct tending to cause or provoke a disturbance. Even assuming arguendo that Alia's post could somehow fall within the catch-all for, quote, otherwise disorderly conduct, the Wisconsin Supreme Court has squarely held that the disorderly conduct statute may not be applied to First Amendment protected speech. Therefore, the threats to cite, arrest, and jail Amia or her parents violated Amia's First Amendment rights. And in the conclusions, we see that Amia is seeking a declaratory order declaring that her speech was protected speech, an injunctive order enjoining the police not to cite her or arrest her or threaten to cite or arrest her for exercising her protected speech, nominal damages, and the catch-all whatever else the court deems proper under the circumstances. This really is next level police state, and I mean police state literally. We are now witnessing in real time the actual manifestation of what were hitherto merely the reductio ad absurdum examples that people would use hypothetically. We are witnessing in real time how poorly worded or ambiguously worded legislation can be used to do whatever the authorities want it to do. Amia's post was not a threat, it was not obscene, it was not promoting harassment in any way, shape, or form, nor was it causing in any meaningful sense or any real sense any disturbance. Now, to play devil's advocate and to steelman the argument, some might argue that this is in fact causing a disturbance. Amia's post may in fact cause panic, it may cause people to rush to the hospital demanding tests. It may cause problems for the school, it may cause parents to question whether or not the school should have taken the kids on the trip in the first place. Possibly, but that would be one heck of a stretch of criminal and or penal law to suggest that that's what the provisions on disorderly conduct were intended to prohibit. And this is not a question of appealing to authority, it's a question of appealing to common sense. I think the fact that most people are reacting the way they are reacting now that this story is getting the publicity it deserves is an indication of the absurdity of the situation. One can strawman the opposing argument and give it all the benefit under the sun, but it remains the case nonetheless that a 16-year-old girl and her parents were threatened with potential arrest for not deleting an Instagram post to the effect that this girl suffered what she was told was a certain illness. I don't think this is going to be a particularly thorny constitutional question. I just think we need more of this type of precedent in order for the authorities to know what they can and cannot do going forward. We will see where this goes. To the extent that the plaintiff is seeking nominal damages, I'm not even sure that there can be a settlement that won't involve some form of public apology, but we will see. I will be following the story. If there are any developments, feel free to DM me, tweet at me, post a comment in the comment section, and if you like my videos and you like my content, please be sure to like, share, subscribe in any event. Share my channel with someone who you think might appreciate it, share it on social media, it will help me grow. There is a reason why free speech is often regarded as the most fundamental of the freedoms, and it takes people like the Cahoons to ensure that that freedom is not chiseled away to nothing. May this lawsuit reaffirm the limits of what can and cannot be done even in a time of crisis. And with that said, stay safe, stay healthy, stay sane, check in on your friends and family, and now you know your vlog. Peace out. Booyah.